Namaste and welcome to Lahari's classes. Welcome back to article by article series of Indian Polity. This is the part 3 fundamental rights lecture. Fundamental rights are from article 12 to 35. Since it's going to be a lengthy video, I have divided this part into 3 lectures. In this lecture 1, we are going to understand the articles from 12 to 18. So let's begin. So before we go to the articles, let us understand what are these fundamental rights. These are civil rights guaranteed to all citizens in 6 broad categories, which protect them from state encroachment and ensure them liberty. So these fundamental rights of our country are inspired by United States Bill of Rights. They form the heart of the Indian Constitution. Originally, when the Constitution commenced, there were 7 fundamental rights, but in 1978, with the 44th Amendment Act, the right to property was removed. So there are 6 rights currently. They are right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So let's look into the articles one by one. First one is Article 12, which defines the term state. So what does this state mean? It includes all the government of India, that is government at the center, Parliament of India, government at the states, and legislature of each states. And also it includes all the local bodies and other authorities within the territory of India and under the control of the government. So these fundamental rights are enforceable against the state. That means if the state is not guaranteeing you your fundamental right, you can approach the court to enforce your fundamental right. So see, Parliament does also come under the definition of state. Also these things like the PSUs, LIC, BSCs, IDBI Bank, ONGC, all of these which were came into existence through an act of the Parliament also come under the definition of state. So simply state means anything that is under the control of the government. So that's it. It's as simple as that. So next is Article 13. It states that the laws inconsistent with fundamental rights. So there are basically 2 aspects of this Article 13. That is in Clause 1, where they discuss about pre-constitutional laws, and in Clause 2, post-constitutional laws were discussed. So what does this Article 13 Clause 1 says is, all pre-constitutional laws, that is the laws that were existing before the commencement of the Constitution, which conflict with fundamental rights, shall be void to the extent of inconsistency. For example, there were a lot of British acts that used to be in prevalence before the commencement of our constitution in 1950. So those laws, if they come in conflict with the current fundamental rights, then they can be said as null and void. Okay, similar on these lines only, in the state of Bombay versus F.N. Balsara 1951 case, some parts of the Bombay Prohibition Act were struck down as they were violating the right to trade, Article 19(1)(g). That is, if the law is like this, even if some part of the law is in conflict with fundamental rights, actually according to this act, there was a ban on the trade of some ingredients, some alcoholic ingredients that were used to manufacture medicines. So, but a case was filed. So the court struck down that part of the law which came into conflict with the fundamental rights, and remaining part of the law was existing as it is. It was applicable. And next is post-constitutional laws, that is those laws which were made after the commencement of the constitution, same thing. If they come in conflict with the fundamental rights, they can be declared null and void. So in the Minerva Mills case, there was a law that was limiting the judicial review, that is the power of Supreme Court or High Court to review its own judgments, was held unconstitutional for violating the basic structure and fundamental rights. Next is Article 13 Clause 3, which actually defines what a law is. Law is not just the parliamentary acts but also the ordinances, orders, bylaws, rules, regulations, notifications, etc. There is also one term here, laws in force. This term laws in force include those laws made before the constitution but still in operation. So these laws, for example, the IPC, CRPC, these were made in like 1860s. So these were prevalent till 2023. So these were made during the British era itself, but these were prevalent till 2023 until the BNSs. These codes were replaced by the BNS and BNSs. So there is an example, A.K. Gopalan versus State of Madras. In the Preventive Detention Act was tested under Article 13 because it was a law affecting personal liberty. So this person had filed a case because Preventive Detention Act states that any person could be held in detention without any warrant. So this was he filed a case against this, and so the court declared that this is unconstitutional because the law was affecting the personal liberty of this person. Okay. So next is Article 13 Clause 4. This was added by 24th Amendment Act 1971, which states that constitutional amendments under Article 368 are not considered laws. This was upheld by famous judgment, that is Keshwananda Bharati case versus State of Kerala. The court had upheld the 24th Amendment Act and also said that the constitutional amendments which destroy the basic structure and fundamental rights of the Constitution will be declared null and void. So next is Articles 14 to 18, that is right to equality. So basically Article 14 discusses about equality before law and equal protection of laws. Article 15 discusses about prohibition of discrimination on certain grounds. Article 16 discusses about equality of opportunity in public employment, and Article 17 about abolition of untouchability, and Article 18 about abolition of titles. Let's discuss each one of them in detailed manner. Article 14. Article 14 has two key concepts, that is equality before law and equal protection of laws. Let's understand what is this equality before law first of all. So it simply states that everybody should be treated equally. See, in this picture we have different kinds of people of different genders, different age groups, like this is a old person, this is a middle-aged person, a woman, a girl, here is a physically challenged person, like different kinds of people. But this article says that everybody should be treated equally. In some aspects it is okay. It also includes that even if it's a prime minister, even if it's a central minister, whoever in a higher position will be treated equally with the common man. In some cases it is fine, but in some cases it is not okay, because these people should be given some special privileges, special rights. So this is this concept, equality before the law, that is no special privilege, all are equal before ordinary law. Basically this concept has been originated in British. It was taken from Rule of Law by A.V. Dicey. So this is a negative concept basically. That means no person is above the law. In certain cases, it is fine. See, if a minister commits a crime and if a common man commits a crime, both should be treated equally, like both should be given the same punishment. In such cases, this equality before law is fine. But in cases like these, people with special needs and special requirements do require some special privileges. So in this case, there is an example I've quoted here. Indira Nehru Gandhi versus Raj Narayan 1975 case. Election laws giving special treatment to the PM were struck down because they were violating the right to equality. So let us look at the next another concept that is under Article 14 only, that is equal protection of laws. This is an American concept which was inspired from the US Constitution's 14th Amendment. So what does this say is we should treat similarly in similar circumstances. Similar treatment in similar circumstances. So this is a better treatment than the before one. So this is a positive concept as it allows for reasonable classification. For example, look at this picture. See, there are different people of different heights. So this is a tall person. He can watch the players playing without having any fence, like without having any support. But look at these two people. They require some kind of support. Right, this person is shorter one amongst these three, so he requires two more supportive stools in order to watch the players. So this is the concept of equality. Like we have given all three of them equal height fences, but in terms of equity, that is equal protection of laws, we have to treat people differently. Because their needs are different. So that is being mentioned in this article, that is equal protection of laws. Hope you understood this concept. Next is Article 15, prohibition of discrimination. That is, the state cannot discriminate any citizen on grounds of religion, race, caste, sex or place of birth. See, Article 15, there are 5 aspects here. In Article 16, we will see the grounds being 7. Here there are 5. So 15 clause 2 says, no citizen shall on these grounds be subjected to any disability in access to shops, public restaurants, hotels and places of public entertainment, or use of wells, tanks, bathing ghats, roads. That is, generally speaking, any kind of public property could be accessed by any citizen. There shall be no discrimination. That is what these two articles are speaking about. And next, Article 15(3) says the state can make special provisions for women and children. Like women are being given reservation at the panchayat level in some educational institutions. So this is not illegal or unconstitutional, because in the constitution itself it has been mentioned that the state can make special provisions for women and children. Article 15(4), this was added by First Amendment Act 1951, which this case, the Champakam Durai Rajan case, led to the introduction of this First Amendment Act in the Constitution, which states that the state can make special provisions for the advancement of socially and educationally backward classes or for scheduled castes and scheduled tribes, like giving reservations in education. The state can provide. Next is Article 15(5). It is very similar to Article 15(4), that is giving special provisions in educational institutions for the advancement of backward classes, SCs and STs, including the private ones, except the minority institutions. So this was added by 93rd Amendment Act 2005. And in Article 15 Clause 6, the state may make special provisions including up to 10% reservation for economically weaker sections. Like we have these OCs, the open category students. In those also, economically weaker sections shall be provided with up to 10% of reservation in education, in jobs, etc. So this was added recently by 103 Amendment Act 2019. So the Supreme Court also upheld this as this EWS reservation as constitutional. So remember, Article 15.6 also this amendment also introduced 16.6.2. We will discuss it in the Article 16. So as per this amendment, these two articles, that is 15 clause 6 and Article 16 clause 6 were introduced. Please remember. Let's go to Article 16, that is equality of opportunity in public employment in seeking jobs. So Article 16 clause 1, there will be equality of opportunity for all citizens irrespective of anything. There will be equality of opportunity. And next is Article 16.2. These grounds are very important. That is, no citizen shall be discriminated on these grounds in public employment. That is religion, race, caste, sex, descent, place of birth or residence. They cannot be discriminated. That is, let's say if Andhra person can work in Telangana, can work in Karnataka, can work in Jammu and Kashmir, so they cannot, the state cannot deter that person from working anywhere in the country. So this is the gist of it. The example is Indira Sahni case, very famous one. Reservation cannot be solely on the basis of caste, must identify social and educational backwardness. So without having any backwardness, no one can avail reservation. Next is Article 16 clause 3. Parliament can make a law prescribing residence requirements within a state or union territory for certain employment or appointments. So this says that Parliament can make a law, like for example, in most of the jobs given under the state governments, they ask you for a residence certificate. That means you have to show them a proof that you have been a resident of this state since like 5 years or 10 years in order to avail that job opportunity. So in that cases, the Parliament can make a law. There is no restriction on it. See the example, Public Employment Requirement as to Residence Act 1957 passed under this clause for certain special cases like Telangana region earlier. Next is Article 16 clause 4. The state may make provision for reservation of appointments or posts in favor of any backward class of citizens which in the opinion of the state is not adequately represented in public services. So in the Indira Sahni case, it upheld the 27% reservation for OBCs but capped total reservations at 50%. So 50% could be UR categories ones and 50% could be up to 50% only. The reservations can be capped. Okay, it should not cross beyond 50% as per the Indira Sahni case. Next is Article 16.4a. It allows reservation in promotions for SCs and STs. So even the reservations are there in promotions for these two sections. In this case, M. Nagaraj versus Union of India, it upheld the validity of promotion reservations based on the backwardness and inadequacy of representation. And Article 16.4b, it was added by 81st Amendment Act 2000, allows carrying forward of unfilled reserved vacancies. So carrying forward, we often hear this term, the vacancies have been carried forward. So according to this article, it is constitutional and should not exceed 50% cap. And Article 16.5 clause 5 provides that this article does not prevent religious or denominational institutions from preferring their own members in employment. See, What does this, in simple words, you often hear about the term endowment. These endowments acts for example, for Hindu temples, only Hindus are allowed to take that examination, and only Hindus are allowed to get those jobs. So the state can make, according to this article, this is not unconstitutional, the state can make such laws and such acts so that the particular religious persons are taken into jobs. Like the religious institutions like temples or madrasas can appoint their own followers without violating Article 16. I hope you understood. Next is the final one in Article 16, that is Article 16 Clause 6. It has been added by 103rd Amendment Act, which gives 10% reservation for economically weaker sections in public employment. Because Article 16 talks about employment. So this was upheld by the Supreme Court also in the Janahit Abhiyan versus Union of India case 2022 as constitutional. So next is Article 17, that is abolition of untouchability. There is no such thing called untouchability in the constitution, but since ages it has been a practice in our society. So in the constitution a separate article was introduced to abolish this kind of discrimination. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be considered an offensive, punishable offence in accordance with the law. So applies to both the state and private individuals also. So it ensures social justice and equality under Part 3 Fundamental Rights. So Parliament also enacted these two laws under Article 17 in order to prohibit this untouchability. That is Protection of Civil Rights Act 1955, which makes the practice of untouchability a criminal offence. Any person could be put into jail if they do not obey this act. And also SC or ST Prevention of Atrocities Act 1989, there will be stronger penalties and special codes for offences against SCs and STs. And the last one for this video is Article 18, abolition of titles. So what does this say is Article 18 Clause 1, the state shall not confer any title on any person except military or academic distinctions. Like no honorary or hereditary titles like Raja, Rajadiraja, Sir, Lord, these are not considered constitutional, and the state cannot give such titles to any private individuals. Titles such as Bharat Ratna, Padma Awards are not prohibited. The state can confer upon these titles Padma Shri, Padma Bhushan, Padma Vibhushan, Bharat Ratna, all of such as a recognition of merit, but not as titles of nobility. The Supreme Court also upheld this article, this clause, as constitutionally valid. But the state can give military titles and academic distinctions like doctorate in the academic distinction. Like in the military, it's lieutenant colonel, like subedar. These titles can be used and can be conferred upon that person. And Article 18 Clause 2, no citizen of India shall accept any title or honours like Sir or Lord from any foreign state. So not just India, but any other foreign countries should not confer upon an Indian citizen these titles like Sir or Lord. An Indian citizen must seek President's permission before accepting any foreign awards. Please keep this point in your mind. In order to accept any foreign title or foreign awards, a person needs to take permission of President before accepting these awards or titles. Next is Article 18 Clause 3. this is for foreign individuals who are working in India. So no person who is not a citizen of India, while he holds any office of profit or trust under our country, under the state, cannot accept any title from any foreign state without the consent of our president. These clauses are made just to protect the nation's security and integrity. So Article 18 Clause 4 states, no person holding any office of profit or trust under our state, that is India, shall without the consent of the president accept any present, emolument or office of any kind from or under any foreign state, because it prevents the foreign influence or conflict of interest among Indian officials. This is very important to protect our nation's security and integrity. If the citizens working for our country gets influenced by other countries and share sensitive information of our countries to that country in the interest of gaining something from the foreign countries, that becomes a threat to our own country. So these clauses were added in order to protect our country and to prevent the foreign influence. So this is all about the articles in this lecture 1. So in the lecture 2, we will discuss the fundamental rights from articles 19 till 28. So thank you so much for watching till the end. So whoever watched till the end, please like the video, comment and share it with your fellow aspirants. Thank you so much for watching. Please subscribe for more Indian polity lessons. God bless you all. Jai Hind.